Have you ever wondered what really happens to your money the moment you're no longer here to protect it? Maybe you've spent years working, saving, investing, and doing your best to build a legacy, only to find yourself lying awake at night, worrying about whether your family could lose everything you've worked so hard to provide. If that thought has ever crossed your mind, stay with me until the very end of this discussion, because I'm going to reveal 5 massive financial mistakes people over 60 often make that can put their families at risk of losing thousands, sometimes hundreds of thousands, of dollars. And be sure to hang in there, because at the end, I'll share a crucial insight that ties all these mistakes together, giving you a game plan to protect your hard-earned savings and give yourself the peace of mind you deserve. While we're here, don't forget to subscribe to this channel and give this video a like, because your support helps us continue bringing you important and timely information to secure your financial future. Let's dive in. Too often, people assume that once they've reached retirement, or they've passed 60, the heavy lifting of financial planning is done. They figure they've got their pension, maybe Social Security or a 401k, and that's enough. Or they trust that a simple will scrawled out years ago is sufficient to ensure their families inherit everything properly. But unfortunately, that's just not how it works in reality. The rules surrounding inheritance, taxes, probate, beneficiary forms, insurance policies, and property titles can be surprisingly intricate, and a single oversight could create an avalanche of complications. We're talking about extended court battles, unexpected taxes, or disputes between family members that rip relationships apart. Worse yet, it can open the door to unscrupulous outsiders who swoop in to grab what isn't rightfully theirs. The truly heartbreaking part is that it doesn't have to happen this way. By knowing what the 5 biggest mistakes are, you can take practical steps to avoid them, securing your loved one's future and ensuring your legacy remains intact. The first major mistake is neglecting to keep your estate planning documents updated. Maybe you drafted a will 20 years ago when your kids were still in school, or you created a trust in your 50s that suited your life at the time. But life changes, family structures shift, loved ones pass away, new grandchildren arrive, and your assets evolve. Perhaps you sold a house, bought a condo, or started a small side business. Or maybe you had a falling out with a particular relative you once planned to leave money to. If your estate documents don't reflect your current reality, you can't expect them to carry out your true wishes. Even if you think, my will is simple, split everything between my 2 children. It's possible that the language you used, or the default language a lawyer used 2 decades ago, can lead to confusion, especially if you didn't specify how certain assets, like a retirement account or a life insurance policy, should be handled. Many older estate documents lack contingent beneficiaries, meaning that if your primary beneficiary passes away before you, your money might be distributed based on state law instead of your intentions. Or maybe your will references an asset you no longer own. These inconsistencies create a perfect storm for conflict and even expensive legal battles that can drag on for months or years, draining the estate. To avoid this nightmare, regularly review your will, trust, and beneficiary designations, perhaps once a year or whenever a major life event occurs. Check who's named, confirm they're still living, confirm they're still the right person to inherit, and make sure you haven't overlooked smaller items that might hold significant value, whether that's jewelry, collectibles, or intangible assets like digital property rights. A quick consultation with an attorney who specializes in estate planning or elder law can ensure these documents are up to date, reflect your current finances, and meet all the state-specific requirements. In some places, for example, a handwritten will might not be recognized if it lacks certain formalities. You'd be stunned by how often families discover these technicalities only after it's too late. By then, the courts can decide the final outcome. If any of this resonates with you, consider subscribing to our channel if you haven't yet. We talk about critical, real-life issues like this all the time, and a simple click helps us continue offering valuable content. The second big mistake is relying solely on a will to protect your assets, not realizing that plenty of what you own might bypass the will entirely. See, certain accounts, like IRAs, 401(k)s, and life insurance policies, are transferred based on beneficiary designations you filled out, possibly decades ago, often when you first opened the account or started that job. If you wrote your sister's name or your ex-spouse's name as the beneficiary 30 years ago, that's who legally gets the money, regardless of what your will says. The same principle applies to joint accounts or property held in joint tenancy. Ownership might automatically transfer to the surviving joint owner. It's a common misconception that your will covers absolutely everything you own, but in reality, it often only covers assets that aren't handled by other means. So imagine your will states that your entire estate goes to your current spouse or children, but your old 401k at a former employer still lists your first spouse as beneficiary because you forgot to change it when you got divorced 15 years ago. The heartbreak occurs when the new spouse or your children discover that entire account goes to the ex because of the beneficiary form, and there's virtually nothing they can do about it. It sounds unbelievable, but it happens more often than you'd think. The solution is straightforward: systematically review every single policy and account, IRA, 401k, pension, life insurance, annuity, and bank accounts that allow for payable on death or transfer on death forms, and verify that the beneficiaries match your intentions. While you're at it, check if you've properly named contingent beneficiaries. This ensures that if your primary beneficiary predeceases you or can't inherit for some reason, your money still goes to a person or entity you choose, rather than funneling through probate or defaulting to someone else. Likewise, if you hold real estate with someone else, find out exactly how the title is held. Are you joint tenants with rights of survivorship, tenants in common, or something else? The wording can drastically affect how that property is passed on. Updating these designations may feel tedious, but it's infinitely simpler than the chaos and legal costs your family might face down the road if they're forced to battle or untangle outdated beneficiary forms. The third looming mistake is failing to address or plan for potential long-term care costs. As we get older, the risk of needing assisted living, in-home care, or nursing home care goes up significantly. And the costs are astronomical. Some nursing homes run well over $100,000 a year. Without a clear plan, paying out of pocket can rapidly deplete assets you intended to leave your loved ones. You might think, "Oh, Medicare will cover it." But in reality, Medicare typically only covers short-term rehab stays, not long-term custodial care. There's Medicaid for those with very limited assets, but qualifying often requires a spend down of nearly everything you own. This can leave a healthy spouse or future heirs in dire straits if you need extensive care. So how do you avoid this trap? Many people explore long-term care insurance. But the best time to buy a policy is often in your 50s or early 60s, before health issues arise that might make premiums exorbitant or disqualify you entirely. Even if you feel you're too old for a standard long-term care policy, newer hybrid products combine life insurance with long-term care benefits, which can still protect you and your heirs if you never need that level of care. Another avenue is strategically repositioning assets so you can qualify for Medicaid without spending every dime, though this requires sophisticated planning well in advance because of Medicaid's look back period, typically 5 years. Some people opt for irrevocable trusts that shelter certain assets, or they rely on legal strategies that ensure the healthy spouse isn't left destitute. The key is to plan early, because waiting until a crisis occurs often means it's too late. You don't want to face the choice between paying $8,000 a month for a nursing home out of your retirement funds or leaving your spouse financially insecure. Talking with an elder law attorney or a financial advisor who specializes in retirement and estate planning can help you navigate these waters. It might not be pleasant to think about needing help bathing or dressing someday, but ignoring that possibility could cost your family everything. If you appreciate the candor here, consider giving this video a like and leaving a comment. It helps more people find this conversation and potentially save their own families from financial disaster. The fourth major mistake is not discussing your plan, if you even have one, with your loved ones or key decision makers. Think about how many adult children have no idea whether their parents have a will, where their parents keep vital documents, or what kind of funeral arrangements they want. The result is confusion and stress when the parent passes or becomes incapacitated. Even if you've meticulously prepared the perfect estate plan, if nobody knows it exists or can't locate the documents, your carefully laid plans might be overshadowed by frantic guesswork. Furthermore, If you've picked someone to serve as your power of attorney, POA, or healthcare proxy, you should absolutely make sure they're comfortable taking on that role and that they know your wishes. Perhaps you put your cousin as your financial POA 10 years ago, but you rarely speak to them now, or they've moved across the country. That might make it difficult for them to effectively manage your affairs when the time comes. Or you might have designated one adult child as the executor of your will, but you never actually asked them or provided instructions, leading to resentments or misunderstandings among siblings after your death. Having honest conversations about who's responsible for what accounts exist, how to access them, and what sort of end-of-life care you would prefer can feel uncomfortable. None of us likes to dwell on our own mortality. But if you don't talk about it now, your family may be left grieving and simultaneously scrambling to figure out your finances, funeral details, or medical choices, perhaps even disagreeing among themselves. You can spare them that turmoil by being transparent while you're able. Additionally, consider leaving a letter of instruction, which isn't a legal document but a personal note to your family explaining anything that might not fit neatly into the legal forms. For example, you might express which family heirlooms you'd like to go to which relatives, or clarify your hopes about how certain assets should be used, like a grandchild's education, even if it's not legally binding. This letter can also include passwords to digital accounts or details about bills that need to be paid. Many families find such a letter tremendously helpful as they navigate the immediate aftermath of a loved one's passing. The fifth, and arguably most overlooked, mistake is assuming that you have plenty of time to sort all this out, or that your situation is too simple to need formal planning. Life is unpredictable. Illness or accidents can strike at any time, and if you're unprepared, your loved ones may be forced into chaotic decision-making. Equally dangerous is saying, "I don't have that much in assets, so it's not a big deal." Even a modest estate can lead to stress and confusion, especially if there are personal items with sentimental value or if the ownership of certain bank accounts isn't clearly established. You'd be amazed how many moderate estates end up wasting thousands on legal fees just to straighten out a probate mess that a few hours of planning could have prevented. There's also a misconception that estate planning is only for the super rich or for older seniors in their 80s or 90s. But the decisions you make in your 60s can shape the next 2 or 3 decades of your life and how your estate is handled when you pass. Health events can drastically alter your capacity to make decisions, so if you wait until you're older, you might lose the chance to arrange things on your own terms. Plus, certain strategies, like setting up a trust or purchasing long-term care insurance, are far more accessible and effective when done well before a crisis. If you're healthy and of sound mind right now, that's precisely the best time to get your house in order. Now you might be thinking, "Okay, I see the pitfalls, but what do I do next?" Well, that brings me to the crucial insight I promised to share. The key to truly safeguarding your money and your family's future is adopting a proactive, ongoing attitude toward financial and estate planning. This means not treating estate planning as a one-time event you handle and forget, but rather something you revisit periodically, let's say annually or biannually, to ensure everything's still aligned with your life circumstances. You wouldn't expect a 20-year-old retirement plan to still be ideal today, so why assume a 20-year-old will or an out-of-date beneficiary designation is still the best reflection of your wishes? This also means building a relationship with professionals you trust, whether that's an attorney, a financial advisor, or both, who specialize in elder law and estate planning. They can guide you through updates in the law, help you structure a trust if needed, advise on new insurance products that might protect your assets, and ensure all your documents reflect your current reality. It's an ongoing process, not a set it and forget it scenario. Adopting this approach also means you'll keep your family or close friends informed, so they know where to find documents and how to carry out your wishes. Maybe you create a secure folder, physically or digitally, containing your legal papers, insurance contracts, a list of accounts and passwords, and instructions for what to do if you fall ill or pass away. That way, no one's rummaging through drawers or old emails trying to piece together your financial puzzle. If you haven't yet, do subscribe and like this video, because we have more detailed guides planned that dive deeper into each of these areas. from the ins and outs of setting up trusts, to strategies for handling inherited IRAs, to how to protect your home from forced sales for nursing home costs, and so on. Meanwhile, let's explore a bit more about how these 5 mistakes can impact your family's well-being beyond just money. When an estate is unprotected, or riddled with conflicts, it can tear families apart emotionally. You've probably heard horror stories of siblings who never speak again after fighting over a family home, or a cherished piece of jewelry. Or a second marriage where the children from the first marriage feel cut out or resentful because the estate plan was never adjusted. The emotional toll can be devastating, leaving scars that last a lifetime. By avoiding these 5 mistakes, you're not merely saving money, you're saving your loved ones from heartbreak, resentment, and confusion. Think of it this way: the greatest gift you can give your family isn't just a sum of money or property, it's clarity and harmony. It's the comfort of knowing exactly what your wishes are and the reassurance that they can handle everything seamlessly when the time comes. That's a priceless legacy. I want to touch on each mistake in a bit more depth to ensure you leave here fully informed. Returning to mistake number 1, letting estate documents become outdated. It's essential to understand that estate laws differ by state, and they also change over time. If you move states or your state passed new legislation, your existing will or trust might require tweaks to remain valid or effective. For instance, certain states have elective share provisions that guarantee a surviving spouse a portion of the estate, regardless of the will's contents. Or they have community property laws that override what you might want if you're in a second marriage. If you're not factoring these rules in, your entire plan can unravel. An out-of-date will might also reference executors who are no longer alive or are otherwise unable to serve. Or it might rely on tax rules that existed years ago, but have since been replaced. This is why it's not enough to create a will in your 50s and assume that's it. You need to revisit it regularly, especially after major life changes, like a marriage, divorce, birth of a grandchild, significant changes in your assets, or relocating to a different state. An estate planning attorney will typically suggest reviewing your documents every few years, or earlier if a big life event happens. If your scenario is complex, like owning property in multiple states, having a family business, or dealing with special needs beneficiaries, the importance of reviewing is doubled, because complexities breed higher risk of mistakes. Let's circle back to mistake number 2, ignoring beneficiary designations on retirement accounts, annuities, or life insurance. It can't be overstated how crucial it is to verify that the beneficiaries match your current intent. If the forms are missing altogether or incomplete, the money could wind up in probate, which is a headache for everyone. Equally problematic is naming minor children as direct beneficiaries. Courts might appoint a guardian to manage the funds, leading to more expense and bureaucracy. Or you might have inadvertently left out certain grandchildren who were born after you set up the account. The bottom line is, if you want a family member, or a trust for that family member, to receive a particular policy or account, make sure the paperwork explicitly says so. Even the best drafted will can't override an out-of-date beneficiary form. You may also want to think about how the beneficiary designations align with your estate's overall tax situation. Some people discover that, by careful naming of beneficiaries, they can minimize certain taxes or ensure a more efficient transfer. These are details to discuss with a financial planner, but they can have a big impact on how much of your money actually ends up in the hands of the people you love. And that leads to the third mistake, failing to plan for long-term care costs. We see seniors lose their entire nest egg in a matter of a few years of nursing home care. If you want to protect a home or certain assets for your heirs, you must act before a health crisis hits. That might mean exploring a Medicaid asset protection trust or other legal tools that reposition certain assets outside of your name in a way that meets Medicaid's guidelines. But these strategies typically require a 5-year look-back period, so if you wait until you're on the doorstep of a nursing home, it might be too late. Long-term care insurance, if you can afford it and can qualify, can be a lifesaver, because it means you won't have to drain your resources to pay for care. These policies come in different forms. Some reimburse you for costs, others pay a set benefit. Some even let you receive care at home, which is where many people prefer to stay. The conversation about long-term care might also include discussing caregiving arrangements with your children if that's relevant. But expecting them to shoulder the financial or emotional burden of your care if you haven't planned properly can strain relationships. Making the plan now, while you have the mental capacity to weigh the pros and cons, ensures your final years won't be marred by panic or forced decisions. Mistake number 4. Neglecting open communication is just as serious as the logistical oversights. If you have more than one child, for example, do they each know their role in managing your estate or medical decisions? Are they aware of your preferences for end-of-life care? Surprises can breed mistrust. One child might feel slighted if they find out too late that they've been left out of a will or were assigned a lesser inheritance. Tensions can erupt, especially if one sibling suspects another sibling might be influencing you behind the scenes. Even in smaller families, a lack of clear discussion can trigger harmful rumors or resentments. Ideally, you sit down as a group, if that feels comfortable, and explain. Here's the basic plan. Your brother will be executor. Each of you will get these shares, and if something happens to me, I want these medical interventions. You don't necessarily have to detail every dollar, but clarity helps everyone feel respected and informed. Plus, it gives them a chance to voice questions or concerns while you're still around to address them. A lot of families find relief once they break that taboo of talking about money and death. It can be a constructive, caring conversation rather than a depressing one. Finally, mistake number 5, failing to take action because you assume there's still time, can undermine everything else. This sense of complacency can be dangerous. Life happens faster than we think, and you don't want to be caught unprepared. The best approach is to adopt that ongoing strategy one mentioned. Treat estate and financial planning as a process. Set a reminder to revisit your plan every year or two. Keep an organized list of accounts, policies, real estate holdings, and relevant contacts. Each time your life changes, ask yourself how it affects your estate. It might feel like an extra chore, but it's a small price to pay for securing your family's future. Another aspect of taking action is ensuring you're living in a financially sustainable way. Sometimes people over 60 continue to accumulate debt. Maybe they co-sign a loan for a grandchild or rack up credit card bills, figuring they'll handle it later. But if your passing leaves behind large unpaid debts, your estate might have to sell key assets to cover them, reducing what's left for your family. Paying down debt, living within your means, and building a cushion can be just as critical as having the right legal documents, because it keeps your estate from being saddled with obligations that overshadow your wealth. Also, be aware that certain debts can outlive you. Federal student loans typically don't pass on to heirs, but private student loans or co-signed debts can. If you co-sign something for a child or grandchild, the lender might come after your estate to settle it. That's not a scenario you want your family to face unexpectedly. If you see these issues might arise, plan accordingly, communicate with the borrower, ensure they're aware of the stakes, or reconsider co-signing if it puts your estate at undue risk. At this point, you might be thinking this is a lot to keep track of. But remember that final piece of advice: be proactive and methodical. That's truly the best way to avoid these pitfalls. If you're unsure where to start, make a checklist, update or create a will or trust that accurately reflects your wishes, check your beneficiary designations on every account, explore long-term care options, have conversations with your future executor and heirs, and schedule periodic reviews of your entire plan. Some people find it helpful to keep a binder, physical or digital, containing all the relevant documents, contact information for lawyers, accountants, and financial advisors, as well as instructions for what to do upon incapacity or death. Let at least one trusted individual know how to access that binder. Another question that might arise is how to handle real estate. If you have multiple properties or a family vacation home, specify exactly who inherits each property, who pays the taxes and maintenance costs, or if the property should be sold and the proceeds divided. A lack of clarity can leave your heirs burdened with decisions they might not want to make, potentially forcing a sale of a property they'd hoped to keep. Similarly, if you own real estate jointly with someone who isn't your spouse or child, like a friend, sibling, or business partner, clarify what happens to your share. Does that person automatically get full ownership, or does your share pass to your heirs, forcing them into an uncomfortable partnership? You can set up agreements or legal structures in advance to handle these possibilities. Beyond the big assets, consider sentimental items. It might sound small, but items of sentimental value, like a family heirloom, a piece of art, or even a photo album, can be the spark for huge family disagreements. Maybe you promised a certain ring to your daughter years ago, but you never put it in writing, and now multiple relatives want it. A simple note in your will or a letter of instruction can eliminate conflict. The emotional toll of watching siblings feud over personal belongings can be worse than the monetary losses. By being meticulous about even these smaller details, you protect the family bonds that mean so much to you. Speaking of family bonds, it's also wise to have a plan for your digital life. Social media accounts, email, online banking, subscription services, or any digital assets that store value, like cryptocurrency. Provide instructions on how to access these accounts, or designate someone legally to manage them. The laws surrounding digital inheritance can be murky, but at minimum, you can keep a secure list of usernames and passwords so your executor or family members can close or transfer accounts without a drawn-out process. Now, what if you're worried about who specifically controls your finances if you become mentally incapacitated before death? This is where a durable power of attorney comes in. If you don't name someone while you're still of sound mind, the courts may appoint a guardian or conservator. That can be expensive and might not be the person you trust the most. By proactively naming a POA, you keep control of that decision. And you can name a healthcare proxy or create an advance directive that details your medical preferences if you can't communicate them yourself. These documents ensure that if dementia or another condition robs you of decision-making capacity, someone you trust can step in and handle your finances and medical choices in line with your values. It's all about preventing confusion and disputes. Equally important is verifying that you genuinely trust whoever you pick. Sometimes people choose a child out of tradition, not realizing that child might have credit issues or a gambling problem. If you sense potential problems, you could require that they consult another family member or a professional advisor before making large transactions. Trust, but also verify. And if you sense any friction among heirs, you might add clauses or structures to safeguard your legacy. For instance, you could create a trust with a neutral third-party trustee who distributes assets according to your instructions, removing the possibility that one sibling is accused of favoritism. Of course, all of this can sound daunting, which is why the proactive approach I keep emphasizing is so crucial. You don't have to tackle everything in one weekend. Start with the most urgent tasks, like verifying beneficiary forms, then schedule an appointment with a qualified attorney to review or draft estate documents. Next, explore your long-term care planning options. Then gradually turn your attention to discussing your plan with family. Step by step, you'll establish a robust fortress around your legacy. When you reflect on it, taking these precautions is an act of love. It's ensuring that what you've earned in your lifetime continues to serve your family or whichever causes you hold dear, rather than being siphoned away by taxes, court fees, predatory individuals, or mistakes. It's also ensuring your children can grieve your passing without the added burden of financial and legal chaos. The big takeaway is that failing to plan is effectively planning to fail, but it doesn't have to be that way. You have more control than you realize. Remember these 5 mistakes: letting estate documents grow stale, ignoring beneficiary designations, forgetting long-term care costs, not communicating your plan, and assuming you have plenty of time. Avoid them by being intentional, seeking professional guidance, and keeping your loved ones in the loop. And that final crucial insight is simply to treat this planning as a continuous, adaptive process. People's lives shift, financial laws change, new grandchildren are born, real estate markets fluctuate, or you may decide to move closer to family in another state. Anytime you pass through a life transition, revisit your plan and make sure it still does what you want it to do. This one habit can save your family immeasurable pain and protect the legacy you've spent a lifetime building. If you found value in this conversation, take a moment to subscribe and tap the like button. Your support means a lot. And please share this information with friends or relatives who might be risking these very mistakes right now. The more people get informed, the fewer heartbreaking stories we'll see of families losing out on the inheritance their loved one wanted them to have. In the end, preparing your estate is about more than just dollars and cents. It's about peace of mind, knowing that when the day comes for you to rest, the people you love are cared for, your wishes are respected, and your legacy stands strong. That's a gift far greater than money alone. It's the gift of security and clarity, one you can choose to give by planning wisely today. Thank you so much for spending this time with me. I hope you'll stay engaged with our channel, because we're going to keep exploring topics that matter deeply to seniors and their families, from smart investing after retirement to health and lifestyle tips that elevate your golden years. Until next time, remember, you have the power right now to avoid those common mistakes and safeguard your family's future. Take it one step at a time, and let the reassurance of a well-prepared estate bring you the calm you deserve. And don't forget, you can always revisit this video if you need a refresher. Take care, and here's wishing you and your loved ones a secure and flourishing path ahead.